So in a lot of, for example, the immigration cases, there's matters of interpretation running to the various conventions to which Australia is a signatory, and they often raise important questions of international law, and often an appellant, so perhaps a person who's what we call an irregular maritime arrival, such as somebody who has landed at Christmas Island or who is being intercepted at sea, and who up until recently didn't have access to the ordinary mechanisms for review of immigration decisions, will have to petition the Chapter 3 courts for relief of some kind. And you should find those quite easily. Everybody will be aware of the plaintiff LAWS12061 case, and to assist the High Court in arriving at a principled decision, and one that accords with notions of international law or common precepts of international law, which are referred to in international law as conventions, the Human Rights Commission in some cases might intervene, or in other cases might seek leave to appear amicus curiae. And they'll seek to do so even though they're not directly involved by the decision, just to make submissions about how certain things should be interpreted or understood. Section 127 of the Administrative Appeals Tribunal is directed to those sorts of cases in an administrative context. And if, let me just check, is everybody familiar with the note up function on OSLI? What you can do is, if you go to section 127 of the Administrative Appeals Tribunal Act, and then you'll see in the header, starting on the left, it says database search, what it says is index table search this act, notes and note up. If you click on note up, what you get is a list of cases which have considered section 127. And the first one there is Re Island Voice and the Great Barrier Reef Marine Park Authority. I'll just see if there's some indication about who, if anybody, relied on section 27. That's probably not a bad decision to have a look at section 27, the way it works, because you'll see there that the Great Barrier Reef Marine Park Authority, who was a party, submitted that a group called Island Voice was not entitled to make an application for review, and the court appears to have gone through the way that section 127 applies to unincorporated associations such as Island Voice as persons or artificial persons, in the same way that you'll learn a corporation is an artificial person as opposed to a natural person, which each of us are, and talks there about circumstances in which you would intervene. So it's quite similar to intervening or appearing with leave amicus curiae in the High Court, or in any other court for that matter, to assist the decision maker arrive at the correct decision. So hopefully that's answered your question directly, Robin, and points you in the right direction in terms of further research if you're interested in that question of standing. It's certainly a very good question. Is that sufficient, Robin?
Yeah, I'm just, firstly, just one question. You were referring to section 127, whereas I was referring to section 27, but they sound like they're the same section.
No, I'm looking at 27, but saying 127, and that's a product of the fact that I've just spent 8 hours in court and came out about 35 minutes ago. So 27 when I say 127, I was actually referring to 27.
Okay, no problem. That's good. So the next question that I've got then is, are we sort of talking more about expert advisors and people like that?
That's right.
You know,
someone who might have some sort of specialist knowledge or information that they can assist the court with, or somebody who might be indirectly affected, if you like, somehow. For example, if a appellant is, or an applicant seeking review is making an argument or grounds which might have broader application than just the case in which the matter is being determined, then it may be that those other people, and in particular perhaps unincorporated associations or the like, some organisations might seek to intervene and have their say.
Okay, thanks very much for that. Great.
That's all right. Anyone else? No other takers?
Brad, it's Robin again. I've got another question.
Well, Robin, it seems like you're at liberty to ask as many questions as you like until someone else comes up with a question, or...
Yeah, look, I don't particularly like being the only person asking questions here, and I really would like it if some other people did, because I feel like I'm taking over these tubes, but I certainly don't mean to do that. The question that I've got is just having a look at the scope of review for merits review.
Yep.
That, you know, applications can be made for, you know, to challenge the correctness or merit
of
the decision, but also... Sorry?
Are you talking now about Section 43?
Good questions. Could be Section 43. I'm still learning these sections, so I think I'm just talking in general, really, regarding the scope.
Okay, go on.
Sorry. So yeah, scope of reviews and merits review is, you know, being able to challenge the correctness or the merit of the decision, and also the lawfulness of decision.
Yeah.
Does that mean that somebody can actually apply for a merits review and only challenge the lawfulness of a decision, or do they need to apply for judicial review?
That's an excellent question, because what you see so far as the powers which are granted to the Administrative Appeals Tribunal is a very wide power of review, as it's been described. And often there are questions of law which are intertwined with merits review, in the sense that because in our federal system of government, much of government decision making is dependent on fairly prescriptive legislation, which in itself establishes not only what the area of decisions that a member of the executive might be able to make, but also the range of decision outcomes that they can reach. How the Administrative Appeals Tribunal has been designed is to afford fairly substantial capacity to supervise. So taking Social Security as an example, just for consistency, given we've raised it in the last couple of weeks, where a person is, where a member of Centrelink is given powers to make determinations about entitlements, which in some cases might require complex analysis of things such as partnerships. So I once gave a fellow an advice about whether he was still eligible for the aged pension, having regard to the fact that he had had about $900,000 worth of assets which had been sold within about, I think, 6 months it was of his application for the aged pension, and had moved the equity from those assets to an overseas jurisdiction. What the Social Security Act said about that was that he was deemed, therefore, to have those assets, notwithstanding that he'd actually divested himself of them. So, in order to determine whether or not he was actually eligible, it required the Social Security Appeals Tribunal to apply the provisions of the relevant Act, which determines whether you're eligible for the aged pension, and to apply the facts to that law. So to that provision. And so it first required an exercise in statutory interpretation before applying the facts of the case. So if the Social Security Appeals Tribunal were to incorrectly interpret the relevant provision and had applied the provision or applied it in the wrong way, although that's a matter which could be the subject of judicial review, the way that the Administrative Appeals Tribunal Act has been set up is to give the Administrative Appeals Tribunal the power to review the way that those decisions have been made and how the law has been applied, in the same way that you might otherwise expect a court to do in the course of judicial review. And so there is a bit of a crossover, and nothing to be too concerned about, because as we move through the course and you start to become familiar with the grounds on which you can conduct judicial review or merits review, you'll see that there's a bit of a crossover in those general principles. And so the Administrative Appeals Tribunal, in terms of the scope of its power, has a bit of fused jurisdiction. But the first thing to do is to understand how strict judicial review works and how strict merits review works, and then once you've got those basics down pat, you'll be able to understand how a fusion of them could work. Has that answered your question, Robin?
Yes, it does. Thank you very much.
No problem. Now I'll just deal quickly. I think Siobhan has asked a question about who makes the decision as to whether a case goes to merits review or judicial review. The answer to that is perhaps in a very strict sense, it's the applicant or the person seeking the review, and but in a more practical sense, or in reality, it's probably that person's lawyers, because most people are, until they've taken this course and become masters of administrative law, like the rest of you will shortly become, are not going to be in a position to decide which one is the most suitable for them. So in a practical sense, it's the lawyers who will look at a particular problem and they'll say, well, this is a case which can be dealt with adequately through the process of merits review, and where merits review may not be sufficient or is not really what's called for, they might advise judicial review. Or if it's in the federal system, because of the matters we've just discussed surrounding the powers of the Administrative Appeals Tribunal, they may decide to go there and argue the fused nature of the jurisdiction.
Thanks for that.
That's all right. And Jolin's looks like Jolin's in line for being next year's course coordinator, because he answered that question before I did, and it looks to be substantially right. Well done, Jolin.
Brett.
Yes.
Do you think you could go through the problem questions? Because if we don't get any feedback on what we're putting up, we could be going down the wrong pathways. I think it might be useful if we can actually determine whether we have got the right idea about these.
Most certainly. I was actually going to suggest that, subject to any specific questions people might have, and I'm just scrolling through the chat at the moment to see if there's anything else, we can then move to problem questions if you like. Just give me 1 minute, John. Jolyn also adds that merits review doesn't require the applicant to be represented, which is correct, and in a technical sense, nor does judicial review. Every member of this community is entitled to appear as a litigant in person and to argue their own case. It just tends to be that by product of the excruciating study that is required in order to become a qualified lawyer that we tend to be more effective at it than litigants in person. But that doesn't preclude a person from doing it themselves. There's an expression in the law which you all may have heard, which is that the lawyer who acts for himself has a fool for a client, which is a nice little parable about the need for having independent agents who can dispassionately assess your case and reach conclusions based on the facts and the law, and then to be able to articulate it to a person such as a judge or a tribunal member who should have quite extensive learning in the law. And so it's that bridge gap divide which is particularly helpful. So I've got a few people agreeing with my excruciating description. There's a little flipping on me perhaps. John, I think, John, you might be referring to me as Charles Dickens by the length of that answer. I'm not sure, otherwise I won't deal with that any further.
I think it was Charles Dickens who said it in Pickwick Papers.
Ah, okay, fair enough. I thought you might all be offline referring to me as Charlie in your private conversations, but that's reassuring. Okay, well, I'm up to date on the chat board so far. So if unless something else comes up as we move through it, or anyone wants to jump in, I'll just move on to the problem questions for the time being. So let's deal. Let's deal with problem 11, John, or where do you want to start?
As I said, I spent quite a while trying to find the Financial Regulation Act, and I then realised, at least I think I'm right, that it doesn't exist.
Anytime you see an act which is described as a regulation act, you can probably be pretty assured that it's probably fictional, in the sense that we have enabling acts and then we have regulations which are made as subordinate legislation. That's the matter we'll deal with in this course as we move through. So you'll all remember, hopefully, from the introductory subjects, that Parliament passes bills in full form, and that is in complete form, and they have to pass through the parliamentary process and receive the approval of both houses of Parliament and then royal assent through the Governor-General in the case of the federal system, and the state governors in the state system. And in the state systems, as you all know, there are some states which only have single house or single body parliaments now. So, for example, in Queensland, the upper house is no longer in existence. In New South Wales, we have both. But I digress there for a moment. In this case, what we might assume is that it's just called the Administration of the Financial Sector Act. I've just taken these problem questions from last semester so that it's all consistent, and as you move through this course you can have some degree of confidence that you're learning the same thing as people who are doing the full semester or the earlier semester courses. So that's why it's a fictional act, is because that's what the lecturer last semester did. But don't worry too much about that. The critical point in problem question number 11 is that you've got a regulatory agency, like Nation Building Australia is the fictional entity I've been using in our previous lectures, regulating a particular area of the financial sector, that's financial advisors. You've got a fellow called James Bull who is applying to be admitted as a financial advisor, and you've got that regulatory agency making a decision or ruling, same thing for the purposes of this question. Technically, probably regulatory agencies make decisions rather than ruling. Ruling is something strictly, I think, that most of my peers would say is the preserve of the courts. That Mr. Bull didn't meet the requirements under this fictional act. So what he seeks to do is to challenge the decision in the Administrative Appeals Tribunal, and you've got the body making the decision objecting to that on the grounds that the Administrative Appeals Tribunal had no power to rule. What it's asking you to do is to identify really questions of standing and jurisdiction that arise in the context of merits review. So it's a question that, or a problem question, that's really asking you to articulate the broad matters of principle that apply in this area of law. So let's have a discussion about how we might resolve that question. Do you want to lead off, John?
Well, I thought that it does revolve around the fact that for a referral to a merits review, it has to appear within the Act that such a referral is possible.
Which Act?
The Act, the Financial Services Act.
Yeah.
Because unless it states within the Act itself that it can be referred to merit review, then unfortunately I believe that it cannot.
Who agrees and who disagrees with John? Looks like you've got a lot of people in furious agreement with you, John. I might have to be a bit worried that you're after my job.
It's a shot in the dark.
Look, I think everybody's on the right track there. I think what this problem question really at its heart wants you to identify is that as Joe and Robin and others have identified, and which I really think is the basis for the observation you were making, John, Section 25 of the Administrative Appeals Tribunal Act establishes the power to review, or what we might call the jurisdiction, as being dependent on the instrument under which the relevant decision was made, granting a power of review to the AAT. So to answer problem question 11 correctly, you would want to make reference to Section 25. We're getting that feedback again. I think somebody's left their speaker on. Might be you, John. You want to refer to Section 25 of the Administrative Appeals Tribunal Act and explain how, having regard to Section 25, it would depend on what provisions are contained in the Financial Regulations Act, as it's been described in this problem question, and to say if there is a provision of the Financial Regulations Act that says the AAT has power to review, then the Financial Regulatory Agency, also a fictional agency as I've said, their objection would not be tenable. If the Act didn't provide for such a review, then the objection would be tenable.
If that were the case, would Mr. Bull be able to go for a judicial review?
So if the facts of, let's say there were some additional facts in this problem question and it said, assume that the Financial Regulations Act does not grant the power of the Administrative Appeals Tribunal the power to review, what other options does Mr. Bull have, then you would want to go to the issues we discussed in week 2 about the framework for judicial review and work through the criteria in the criteria that apply to seeking judicial review. So we would say, is Mr. Bull affected? Has a decision been made? Does, on a proper construction, the Financial Regulations Act allow the Financial Regulatory Agency to make the decision that it's made, or to make it in the way it's made? And if you answer either of those questions in the negative, then you would be looking very strongly at a potential application of the general power of judicial review that the federal court has over decisions of the High Court, in fact the High Court primarily, by reason of the Australian Constitution, and then alternatively the federal court by reason of the powers granted under the Judiciary Act, to exercise judicial review over the decision, as Jolan points out, having regard to the lawfulness of the decision that was made or purported to be made. Just while we're on that point, Kylie asked a question about whether acts, by which I think you mean legislation, Kylie, which enable the AAT to review decisions, also specify the types of review that the AAT can conduct, or is that completely covered by the AAT? There's no reason, in principle, so far as I'm aware or am concerned, that the government would not be at liberty to limit the power of the Administrative Appeals Tribunal only to make certain decisions. It would probably be rare, and it would be rare because they have, the Federal Parliament has quite deliberately set out within the Administrative Appeals Tribunal the range of decisions which it is empowered to make, and you'll see them set out in section 43. That is the decision to affirm, vary, set aside, make a new decision, or to remit the matter, which is really the full breadth of the sorts of powers that you would expect in this area, and are fairly consistent with the types of orders in substance that courts can make, either on a strict appeal of the kind we discussed last week, or in the nature of judicial review. Does that answer your question, Kylie? Terrific. Anyone got any other questions on problem 11, or did you all want to move on to problem 12?
Yeah, go to 12.
Okay. Anyone wants to ask further questions on question 11, now's the time, or forever hold your peace? Okay. Problem question 12. In a case before it, the AAT considered evidence and matters which were not before the decision maker. Party X argues that the AAT went beyond its powers. Is this correct? What does everybody think?
I would say that as the AAT can act as a de novo reviewer, then they can accept evidence that was not originally introduced, and they stand in the shoes, I think is the expression, of the original reviewer, and yes, they certainly can do that.
Anyone, there also appears again to be overwhelming support for your contention, John. I'm really starting to get concerned about my tenure next semester, at least in this subject. Anyone going to say that John is wrong?
Sorry, it's Robin. John, which section of the AAT Act were you just referring to?
I wasn't actually referring to any particular section. It was just what I had read into the from the notes.
My thoughts were around section 33(1)(c of the AAT Act, but I'm not around the rules of evidence, etc. But I wasn't quite sure if that's where you were.
It could possibly be, and I certainly wouldn't be able to quote which section it came from.
I think between the two of you, you've probably hit the nail on the head so far as full marks for problem question 12 is concerned. I think the starting point is to point out that as a matter of principle, merits review is a de novo review, and it's approaching the decision afresh, or as John says the expression used is, and as John has just said, tribunal stands in the shoes of the original decision maker. And as Robin's quite rightly pointed out, what you find in section 33 of the Administrative Appeals Tribunal Act is a statutory codification of that position to some extent. And you'll see in particular in 2A, this provision, without limiting the operation of this section, which in this section deals with the procedure of the tribunal, a direction as to procedure to be followed at or in connection with the hearing of the proceeding before the tribunal may A, require any person who is a party to the proceeding to provide further information in relation to the proceeding. So I think the two of you really have got a good grasp together, and again a good example of how working collectively you'll really be able to advance your learning in this subject. Any other questions on problem 12, or should we move on? Yeah, so it's section 33, subsection 2, capital A, Robin. Types of directions. That's it. Anthony said, sorry, Peter says 33 subsection 1 as well. Look, probably the thing is when you construe a piece of legislation, as I hope you've covered in Introduction to Law or Statutory Interpretation, you construe an act as a whole, and when you construe a section, you start with the first subsection and you move your way down through the subsequent subsections. And so what we learn from subsection 1 is that basically there is not really any rules about how the Administrative Appeals Tribunal makes its decisions, other than, of course, that overriding notion that it has to afford procedural fairness and natural justice, which we'll do in greater detail as we move through. And then as you get down to 2A, you find not quite a direct expression of the right to consider further information, but what you would say is that by reason of subsection 2 capital A little a, that is that section, hold on, that car shouldn't be there, it should, having a bit of difficulty with these emoticon things, that by implication, if the tribunal can require a person who's a party to a proceeding to provide further information, then it's entitled to consider that information, because obviously giving a direction as to further information would be nonsensical if the tribunal were entitled to do something about that.
Can I just ask a question, Brett?
Certainly, Siobhan, you don't need to ask permission to ask questions, just jump in with them.
So on that point, does the tribunal have the same right to subpoena anybody that they wish, even if they weren't part of the original case?
Technically, subpoenas are the purview of Anthony. I might just get you to turn your microphone off. I think the feedback's coming through. Technically, subpoenas are the purview of courts. What you find as the statutory language or the statutory equivalent in most tribunals is what they call a summons. There tends to be not a great deal of limitation on the use of those summons. Somebody else, Siobhan, I think you've still got your microphone on as well.
Yeah.
There tends not to be any strict limitation on who those summons can be issued to, so far as you'll find a legal provision that limits it. But in practice, tribunals and courts tend to require those sorts of powers to be used sparingly. What they require is that you have to demonstrate good reason why you might need somebody to attend to appear, so you can't just issue a summons off your own back, whereas at least in New South Wales, Victoria, and if memory serves, the last time I was appearing in Queensland, in criminal cases you can just issue a subpoena to anybody. You don't need permission of the courts. So if there's somebody who can assist your case and you need them to be present and they won't come along voluntarily, then usually you can get a summons to get them along even if they're not a party. Does that answer your question, Siobhan?
Yes, thanks for that.
Pleasure. Okay, anyone got any other questions either relating to problem 12 or generally, or do you want to move on to problem 13?
Yeah, let's move on.
Okay, so student, I actually liked this problem because I once represented a person who was involved in student protests who I'm pretty sure was actually a representative of the Chinese government. That I'll say no more about that. Students protested against the visit of the Chinese Defence Minister to the Australian Parliament. When the student protest went out of control, a student, Josh, suffered injuries after he was shoved to the ground and kicked by a member of the AFP. He filed a complaint against the police officer who caused his injuries. After an investigation, the Commissioner of Police made a finding that the police officer involved in the incident was not at fault and decided against taking any disciplinary action against the police officer. Josh intends to have the decision of the Commissioner of Police reviewed and has come to you for advice. He wants to know if he can file an application to the Administrative Appeals Tribunal. What would you tell him? Anyone? What would you tell him?
Well, my answer was that unfortunately the merits review cannot look at this because it's an issue of law and order, and that his only recourse would be to go to the Ombudsman.
And who agrees or disagrees? Anyone disagree with John or have something to add to that answer?
Brad, it's Robin. I don't really have anything to add. I've got more of a question. When I went to answer this question, I tried to find the act that actually regulated this, and I found the Australian Federal Police Act 1979, but I wasn't quite sure if that was the one. But my question actually is I actually spent a considerable amount of time looking through that act to see if the matter could have been taken to a merits review, and I couldn't find anything. So and what I ended up finding was this, referral to the Ombudsman. But my question is, where will it appear in the Act if they can actually take it to merits review? How can we quickly determine that?
Well, the reality is that such is the nature of statutory law and the practice of law more generally, Robin, is that you probably will very rarely, if ever, find a quick answer or an easy answer. And if that weren't the case, I might be out of a job, and you guys may not be minded to think that you have great prospects of obtaining a job. It would ordinarily, you would expect, the way that acts are structured is that you would often find, at least in the Commonwealth, the way that the Commonwealth structures its act, a subdivision towards the back end which says either in the miscellaneous provisions or in provisions which provide for appeal and review of decisions, a section which tells you that it can that a decision made under certain sections of the Act can be reviewed. As Paul has just pointed out, the Administrative Appeals Tribunal, and this is a quick answer, a sort of a cheat or a ready reckoner. On the Administrative Appeals Tribunal website, you'll find a list of acts and instruments under which the AAT has jurisdiction. So sometimes that's a sort of a quick cheat if you're dealing with an obvious sort of case, one that is quite commonly appealed, and you're just looking for the provision for the purposes of knowing what that provision is, and that's always a good practice, even if you know, for example, Social Security can be appealed and tax can be appealed, but you always want to find the precise set of power that allows you to get there in case you're ever asked. Some tribunal members, like some courts, like to play with advocates, a bit of cat and mouse sometimes, or probably should say cats with woolen balls, and they just throw out teaser questions like, well, what's the basis of this application? Where's your head of power? And they just want to take you through, or get you to take them through how you get to court, and that's often just to gauge your level of competence and your level of preparedness. But often you might have a client who's got a novel problem, or one that's not common, and that you need to go and actually find the provisions in order to determine whether or not you've got a basis to get into either the AAT or alternatively the federal court. And to do that, it's really just through hard work and laborious endeavour that you have to search through the Act to find a provision that allows you to get the matter into court. Now, hopefully that's dealt with your question, Robin, but before I completely move on, I just want to deal with the proposition that John put forward, that everyone I think is sort of largely in agreement with about why this particular decision, that is the one in problem 13, is not reviewable. The answer, I think, in essence, probably the outcome that John has reached is probably right, and that at least in part the way that he gets there lends itself to some support. That is, he says generally decisions running to law and order are not reviewable, and probably as a general proposition that is right, but it's not right in every case. So you have to be careful where you take that sort of process of reasoning. You need, if you are going to adopt that sort of reasoning, you need to say, as a general rule, you would expect decisions made by law enforcement bodies rather than law and order, but law enforcement bodies, which are to which they are given a broad and absolute discretion, not to be reviewable. However, and then you need to work through. So, for example, just taking a New South Wales context for a moment, which I know quite well, the laws of New South Wales create an offence for the unlawful and unauthorised assembly of persons, and that's a tricky piece of legislation because it tends to trample on the implied constitutional freedom for political communication, and sometimes even to a lesser extent, although it's not an absolute guarantee, the freedom of movement. And so what the Parliament has done is it said that you can apply or give notice to the Commissioner of Police about a gathering, which in some circumstances the Commissioner of Police can approve or veto. And those sorts of decisions by law, those sorts of law enforcement decisions are reviewable. So that's one, that would be an example of a carve-out. So I tell you that just sort of by way of background so that you know, albeit in earlier sessions we have stated the general rule surrounding law enforcement being non-reviewable, that there are exceptions, and that's why this process of going to the Act and really undertaking extensive research is necessary on a case-by-case basis. In this particular case, what you would say, I think, is that along the lines of what John has said, there's a decision made by law enforcement. It's a decision that's it's perhaps less of a decision than a conclusion, to be frank. What you've got here is the Commissioner of Police conducting an investigation and then reaching a conclusion that the officer was not involved, and then making a decision or electing not to make a decision to take disciplinary action. Now, I think you would expect in the ordinary course that to be something which was not reviewable, which is the ultimate view everybody seems to have reached. But to correctly rationalise that decision, as Robin has done, one needs to go to the relevant legislation, and Robin's correctly identified it in her answer as the Australian Federal Police Act 1979. And to point out that there is no provision made within that Act for that sort of conclusion or decision to be reviewed. That would be a critical point to make. And then come exam time, we should have covered in a fairly broad sense the nature of Ombudsman's review, and as everybody's pointed out, this is the sort of thing that you would probably send to the government for a type of internal review, if you like. Although strictly speaking, the Ombudsman's powers are not entirely a internal type merits review so much as it's an oversight jurisdiction. Have I done that to death, or is there anybody who could possibly want more about that? Siobhan says good. Anybody going to tell me I've done it to death? All right. Doesn't look like anybody wants to hear any more about problem 13, which is good. We might actually get this lecture done on time tonight, which would be impressive. Let's move to, no problem, John, thanks for coming. Let's move to problem 14. Kim operates a car rental business and has been doing most of her business accounting tasks on her own. The ATO conducts an audit which reveals that Kim has misinterpreted key provisions of the Australian tax laws as a result, of that misinterpretation was deficient in the taxes that she has paid in the amount of $4,965. She asked the ATO to review her tax liabilities. The ATO does so and confirms the decision and reiterates her reasons for that decision. She's advised by the ATO, however, that the relevant laws allowed her to have the ATO decision reviewed by the AAT. Kim then sought legal advice to determine the next steps she should take. A tax lawyer was of the view that a proper interpretation of the tax laws and certain factual matters not brought to the attention of the ATO would show that Kim only owed $2,400. At the tribunal, Kim included in the statement of her reasons for her application that the ATO interpretation was wrong, that it failed to consider important factual matters that would have caused a reduction of her tax liabilities. The ATO argues that it's not open to Kim to raise these new matters as they'd not been brought to the ATO. It was argued further that the tribunal's power of review was limited to matters and reasons cited in the ATO decision. Who is correct and why? Okay, who wants to have first go at this?
I guess it's me again, Brett. I actually wasn't quite sure on this one, to be honest. I was a little bit confused with some of the stuff in the notes, but I'll just go through what I said. First up, I said that Section 33 of the AAT Act enables the AAT to avail itself of any information it needs, whether past or present, to arrive at a correct or preferable decision. But then there were some notes on page 18 of the lecture notes, and I couldn't quite understand if they related to this or not, around accrued rights or liabilities and applicable laws. So I'm just wondering if you might be able to tell me if I was on the right track there or not.
Yeah, look, I think everybody, Paul, I hope you're not asking me to reread the question, because I struggled the first time around. But if you just go onto Moodle, you'll find it there. If you go into Moodle and you have a look at the cross-section of answers which everybody has put in, you'll get a sense of the issues which arise. Sorry, Paul, I don't want to delay, so I just don't want to go over it too many times, but have a look at the question and the answers in Moodle, and if you've got any questions, I'm happy to talk to you about them next week. But the long and short of it is that there's a dispute between a taxpayer and the Australian Tax Office. The taxpayer wants to take it to the Administrative Appeals Tribunal. The ATO asserts against the taxpayer that as matters weren't raised with it that now form part of its brief, the taxpayer's brief in the AAT, that the AAT is prevented from considering those matters. You'll see there that, I think it's Annette identified, hold on. You'll see that Annette has identified the division of the Administrative Appeals Tribunal which deals with these sorts of cases, tax disputes under $5,000. being the Small Taxation Claims Tribunal. If you go on and do a little bit of research about that tribunal, you'll have a look at what its powers are. Robin, I think, is right to point out Section 33, which we discussed when we did problem 11. As a starting point, I think you would say the AATs that, yeah, John, it is, I think that's right, it could be it is very similar to question 11. Gordon, I'll come back to your question in just a minute. I've sent out an email about that not an hour or so ago, but I'll come back to it at the end. The ATO are arguing that these new arguments that the taxpayer has come up with can't be heard because it hasn't been determined by the ATO. The ATO is an interesting creature in that it can do all sorts of things that most administrative agencies or executive agencies can't do, such as issue tax rulings. It's a very complex area of law. For our purposes, I don't want you to be too concerned about the depths of the ATO's powers to do rulings or how they stand out as a litigant compared to other agencies. Really, what I want you to focus on in these sorts of questions, particularly given we're only in week 3, is that the power to conduct a review is a de novo review. If the tribunal, the AAT, were inclined to think that it would be advantageous to have the ATO make a ruling on the new grounds which had been raised by the taxpayer before it itself makes a ruling, which is not uncommon in cases where a matter is being ventilated for the first time at the Administrative Appeals Tribunal. It might well send the case back to the ATO for determination, and you'll remember, I think, to answer this question, full marks would be to point out Section 33. As a general proposition, the AAT has broad powers to conduct a merits review. Then go to Section 43 and point out that the range of discretions or orders which can be made by the Administrative Appeals Tribunal include remitting the matter for consideration of the tribunal in accordance with its directions. So some tribunal members hearing a dispute like this might say, well, look, yes, it is a novel point that is being raised for the first time in this jurisdiction. The ATO hasn't had an opportunity to consider it because tax matters are complex. What I'll do is, instead of deciding this case myself, I will remit it to the ATO, get them to make a ruling on this new matter. If they reach the same conclusion as the tax lawyer and conclude that the taxpayer only needs to pay $2,400, then there'll be no need to come back. If the ATO reaches a different conclusion and decides that the $4,000 is still owing, then this appeal option is still open to you, and you can come back up here and the AAT will decide it. So it's sort of whilst there are certainly some strong parallels to problem question 11, what you would also want to be considering in problem 14 is this additional notion of the sorts of orders which are available to the AAT, such as remittance and reconsideration at another time. Now, I'll just go back. I think everybody sort of answered the question about the question that you've raised, Gordon, about assignments. At the beginning of the term, I flagged with everybody that I was going to push it out to give you all a bit more time, and there was an overwhelming, in fact, I think a unanimous verdict of the class that making it due at the end of week 6 on the 13th of December is a good thing. I was not at all surprised by that feedback, and so I adjusted the due date to the 13th of December. I'm not sure why some people don't know but I have received quite a few questions this week about extensions and the like. Some people must have assumed it was still going to be due this week. It's not. It's due the 13th of December, and I've sent out an email to that effect this afternoon. Kylie says, so a decision that is remitted back to the original decision maker can be reviewed again after it has been remade. The answer is yes. If in problem question 14, a decision was made by the AAT to remit the matter back to the ATO, the new decision that was made would be a new decision which would then come up for a review. So it wouldn't be a remaking of the original decision, it would be a new decision and then a new review. Alright, well, I was probably slightly optimistic to think we would finish on time tonight, but we've gone through all the problem questions and a few other questions, and it's 10 past 8. Unless anyone's got any other questions or something pressing, we'll call it a night and everybody can go and have something to eat. Just on a final note, I think based on the feedback or on the contributions that are happening online so far, and in tonight's tutorials, you seem to be on the right track. Any anxieties that you might have had at the beginning of the semester, I hope, are starting to fade away a bit. I assure you that if we maintain this sort of momentum and progress, nobody is going to have too much difficulty getting through the subject. So keep up with the readings and keep coming along to the tutorials, and I think it'll be hopefully an enjoyable semester for you all. Okay, have a good week, and we'll speak to you all next week.